on today's show, I'm joined by my fellow colleague and editorial board member, Joe Rago, who's here to talk about the final day of the 3-day Supreme Court hearings on Obamacare. Welcome,
Hey,
Joe. So, Joe, for those who haven't been following this, have been under a rock and haven't been watching their TV for the last 2 days, tell us, the first 2 days of arguments dealt with what?
Well, we've dealt with if the Supreme Court is going to punt on the individual mandate, maybe they'll say it's just a tax, it doesn't fall under the Commerce Clause, and therefore doesn't upset the balance of federal power and state power.
So we don't need to hear this. So the first day is on, do we need to hear this
right.
case?
And then yesterday was on those core Commerce Clause arguments. And then today we had a debate this afternoon about Medicaid and the expansion of Medicaid and whether that commandeers the states into agents of the federal government. But the really interesting thing was this morning's session where the Supreme Court looked at an issue called severability. And essentially, the whole week they've been looking at, what are the outer bounds of federal power? What can the federal government do and can't do? And today they kind of turned that lens back on themselves. They said, well, what are the limits of judicial power? What does judicial activism mean? What does judicial modesty mean in the context of the decision that they're going to make here?
Okay, so day one, do we need to hear this? Day two, can the government force you to buy something? Day three, can this decision to force you to buy something be separated from the rest of the law?
Right.
So did I get that right?
The issue here, the technical term is called severability.
Okay.
And it's essentially the doctrine that says what happens to the rest of a law if one part of it is found unconstitutional. Now, normally what Congress does is they include something called a severability clause.
What's that?
Which says if you strike down one part of this law, we're going to presume that the rest of it's constitutional. Or they could say, well, if one part's struck down, just get rid of the whole thing. We're done with it. Let's go back to square one.
So they put provisions in to protect themselves from these kinds of challenges, but they didn't in this law.
Right. So
why?
If you remember in sort of the madcap dash to get the Affordable Care Act through the House and Senate on a bare partisan majority, they sort of passed over a lot of technical issues, and a severability clause is one of them. And the case law on severability is just a total mush. So it's really up to the justices themselves to decide, well, how far do we go here?
We're talking to Wall Street Journal editorial board member Joe Rago on the third day and final day of Supreme Court hearings on Obamacare. So, Joe, I know this might be a tough question because we just got the transcripts of the hearing. We've only had a couple hours to digest them, but can you tell us anything that you learned today about the arguments?
So here's the question they're kind of grappling with. There's now sort of a growing realization that the court may overturn the individual mandate. Now, we know the individual mandate is used to subsidize other parts of the law that make regulation more expensive. Therefore, that's tied to the exchanges. These are the Obamacare marketplaces where everyone will buy insurance. The exchanges are tied to the new entitlement subsidies, which are in turn tied to the new Medicaid expansion. Sort of the entirety of the law has this individual mandate right at the heart. And one of the things, you've got the left out in force saying, if you strike down the individual mandate, you are just conservative judicial activists. But one of the things that came up at this hearing today is they said, well, if we strike down the individual mandate, we'll just have these regulations on the books that are driving up costs. This is something Congress never intended. This is something that no one in the on the political branches ever envisioned. So wouldn't it be paradoxically an act of judicial modesty to say, well, we're getting rid of the individual mandate and we're getting rid of everything else too. Back to you, Congress. Do this in a constitutional way.
Did some of the justices, like for example Kagan or others, maybe on the more liberal left side of the court, make any compelling arguments against that and make good arguments to keep those regulations?
Right. Well, definitely. The converse side of it is saying, well, if the individual mandate is gone, there are constitutional ways to cross-subsidize regulations that make insurance more expensive. Keep everything else, and Congress just come up with a new financing mechanism. I think that's a legitimate argument too. But you've got there's a growing realization among the court's liberals, I think, about the issues at stake. They're saying, ooh, the Obama administration's demand for totally unlimited federal power, for essentially federal police powers. This is really unprecedented, really worrying for the separation of powers and the basic constitutional structure that protects individual liberty. So, not making any predictions here, but I think they're genuinely discomfited by what they heard at oral arguments this week.
But maybe not as clear-cut today as it was yesterday, the arguments on the individual
I don't
mandate.
think so. You know, nothing about this case is clear-cut. This is really a novel and unprecedented question, and the government has never tried to do anything like what it's trying to do right now. So I think to their
10
credit,
seconds.
to their credit, the entire court has treated this issue with the complexity and the seriousness that it deserves.